Welcome to Sidebar, Bracewell's podcast devoted to government enforcement and investigations, corporate compliance, and white-collar criminal defense. I'm Matthew Nielsen.
And I'm Phil Bezanson.
And we are your hosts, and we are also both partners at Bracewell LLP, where we represent companies, board of directors, and individuals in all manners of litigation, investigations, and enforcement actions.
Today we're going to talk about something that no one wants to experience, but it happens every day. What do you do when the government comes knocking at your door with a great guest, our colleague, Jeff Vaden? Jeff is a former federal prosecutor who investigated and brought cases involving bank fraud, public corruption, export controls, sanctions, counterterrorism, and national security. And he's now been in private practice for over a decade, where he has the pleasure of working with us. Thanks for joining us, Jeff.
Thank you, and happy to be here.
All right. So as we teed this up, 6 a.m, you're just waking up, or in my case, I've been up with my kids for about half an hour already, and there's a knock on the door, and you wonder, well, who could that be? And it's a guy standing there with sunglasses and a jacket, and he's got 4 other people behind him and a rolled up piece of paper in his hand, and says, "Hi, I'm from the government, and I'm here to take a look around." What happens next?
Well, hopefully in that circumstances, your company or the individuals have been prepared in some sense for that eventuality and know how to respond. But I think the first and foremost, you have to understand when federal agents are there to serve a search warrant or execute a search warrant, it's not a choice. They have the right to be there pursuant to a judicial order, and they're going to go in and look for whatever the scope of the warrant is looking. It gives them authority to look for.
Well, is there a way to kind of figure out that that's going to happen and do something ahead of time to maybe, keep that from happening?
Well, I guess if you have some sense that you or your company may be under investigation, you could probably take some steps to reach out to the authorities to try to short circuit a search warrant. But typically these are surprises for most people, at least in some sense. So I think there's some training you can do for your employees to understand what is the most appropriate way to respond to a search warrant, how to interact with the agents, what you should and shouldn't do. So you can prepare in those ways. And frankly, it should be something that should be done in advance so that you don't do something at the time the agents are present that could be interpreted as obstruction or some type of consciousness of guilt.
So Jeff, and we started talking a little bit about search warrants, but there's other ways the government can come knocking. Could you talk a little bit about, other circumstances where you may find yourself suddenly talking to a federal or state agent?
Sure. And for my time as a federal prosecutor, I viewed it as kind of a continuum of interacting with the target or a subject of an investigation. And frankly, the search warrant was often the last resort because one, it's very resource intensive. You gather information in a way that's kind of less controlled and less focused. So you actually end up capturing a lot of information that might not be relevant to your investigation. So when I was doing, for example, export control investigations in Houston, I worked with a very small specialized group of agents. And many times I'd said, before we go to a search warrant or issue a grand jury subpoena, let's just shoot an email to the general counsel or just go out and talk to the target. Many times that gets you where you want to go a little bit faster.
Yeah, I think there's, in the industry, there's something called a knock and talk. You talk a little bit about, what that is and, if you ever encounter that, what you should be thinking and doing and not doing.
Yeah, I've encountered a lot of those either by sending agents out to do them or having clients that were the recipient of a knock and talk. And essentially what a knock and talk is just an agent asking for consent to search and or speak with an individual. Many times agents like to go to someone's house, for example, late afternoon or very early evening, about 6 p.m. Because many times they understand that if you're at home with your family and your neighbors are watching, the natural human reaction is to try to get the police off your porch by inviting them in the house to talk so they can't be seen. And that's exactly what the agents are counting on. And I wish I had $1 for every time I told a potential client or a client, if agents show up to your house, politely decline to talk to them and tell them you're represented by counsel. But usually you get the call that, oh, they were at my house and I spoke to them for 3 hours. What should we do now?
So you mentioned a moment ago things that you should do and you shouldn't do. And it sounds like, you just said a little bit about what you should do. So can you give us an example of things you shouldn't do? I think you used the word obstruction. So can you tell us a little bit about what obstruction looks like and why that's a bad idea?
Sure. You have to keep in mind that in any area of expertise, people they develop a sense of what they think is how it should go. And federal agents are not any different from that respect. So an agent walking into a situation where they already believe or they've demonstrated that they have probable cause that a crime has occurred or is occurring, they're going to walk into that situation a little bit cynical that there are going to be bad things there or bad people there. And that's what their mindset. So while the agents are there, you tell your fellow coworkers or your employees, you don't have to speak to the agents, which is entirely true. But saying that in front of the agents is going to be perceived as you trying to obstruct their investigation. That's why it's important that you need to train your employees beforehand that you don't have to speak to the agent. So you're not saying that in front of them, because the agent's they're there to look for a particular evidence of a crime they think has been committed, and any effort to kind of slow or obstruct or divert from that, they're going to view that as being obstructive.
Well, and let's break that down a little bit, right? Because I think a lot of people don't necessarily understand what their rights are in a given situation. So, there is a big difference between agents showing up with a search warrant where a court has found there's probable cause of a crime, and there is a judicial order that requires you to let the agents in and to search the premises, right? But very different than the situation when you have agents just show up at your door without a search warrant. And could you talk a little bit about when you are required to cooperate and what level of cooperation and how that differs in those situations?
Well, if they show up without a search warrant, I don't know that you're ever required to cooperate. It is voluntary by nature. Sometimes agents or officers will try to suggest that there may be an easier way or a harder way to get this done. But the reality is, if they don't have a search warrant, there's a good chance the reason that is they don't have enough probable cause to get it, or it could be they just don't want to sit down and type up an affidavit and go see the judge. It could be either of those two options. But if they're asking to come into your house and search or speak to you, they're probably going that route because they don't have enough to go another route where they can kind of compel your cooperation.
And then generally speaking, in those situations, what should someone do?
Ideally, they should say, well, I would love to speak with you, but I think I need to confer with my attorney and we can come back to you and talk, because they're not there for no reason. And agents are trained to develop a rapport and get information from people. And I like to tell clients and potential clients all the time, if you lie to a federal agent, it's a federal felony. If they lie to you, it's good police work. So it's not a fair level playing field. So if you go into it thinking that it is, you're likely to make a mistake that's going to cost you down the road.
So you've said a couple of times that a good rule of thumb is to kind of identify that you have an attorney, to say, I've got a lawyer, talk to my counsel, whatever the right phrase is. When someone says or identifies to an agent that they are represented, what should they expect to hear back from an agent, and what should they expect to see? I mean, does it mean that all of a sudden the agent goes away, or does it just mean that the process might unfold a little bit differently?
I think it means the process is likely to unfold a little differently. And that's assuming for right now, we're talking about agents who show up without a search warrant. If you tell them you're represented by counsel, they're probably going to give you their business card and say, hey, either give us a call or have your lawyer give us a call so we can continue that conversation. Now, many times they may try to push the issue, but most of the times, particularly on the federal side, they understand they're a little bit more sophisticated generally than some of the state and local officers. And they're going to take that statement that you either have a lawyer or would like to consult with a lawyer, either one, as a signal that they're going to have to continue this conversation later, or come back with a subpoena and or a search warrant if they want to really get in that premises.
And by the way, I mean, I hear it so often from people, and again, it's like you, Jeff. I get the call because someone has talked to the agent for 3 hours, and the response is, well, I haven't done anything wrong, and I didn't want to signal to them by saying I have a lawyer. You should talk to my counsel. They think that's showing some kind of guilt. I mean, I can tell you from my experience, I've never seen that conversation, talking to the agent for 3 hours go well for that individual, even if they ultimately did not commit any kind of crime. And has anyone ever seen that actually go well for someone?
I think that's a rare occurrence. Typically, I mean, if they're at your doorstep, they're there for a reason. Maybe you're a witness in an investigation, and if you talk to them, and maybe you never move beyond being a witness, but you've committed to a story that they're going to have documented, that maybe if you had under a more reasoned counsel sit down, thought about it, you would have given a more accurate version. So even if you don't get charged, it's still better off to be prepared for the discussion. And there are a lot of factors in my experience, particularly as a prosecutor. I was always amazed by the number of people that gave consent that had done something wrong. I understand if you haven't, the natural reaction is, I haven't done anything wrong. Why wouldn't I talk to you? But an amazing number of people who have done something wrong. I mean, when I was a federal prosecutor, we would send agents out to go knock on doors, and people that had 800 pounds of marijuana in their garage said, sure, you can come in and look, as if they're not going to see it and smell it. Some of it's cultural in my experience. In some countries, when the police ask you for something, they're not really asking.
I do think, just speaking as the resident of Seattle, that if one of my neighbors had 800 pounds of marijuana in his or her garage, they would be completely justified in saying that they've done nothing wrong and they have nothing to hide.
Understood. Not so much in Texas.
Phil, would you like to go ahead and just give your address for our listeners?
My garage currently is full of kids' sporting equipment, so there would not be room for 800 or dramatically less marijuana in my garage. So I have nothing to hide.
Okay, Jeff, let's say, let's jump to the situation when you have the search warrant, this being executed on, your home or your business. What should that person do?
Well, hopefully, if it's a company particularly one of any size, you've prepared for this day that you hope never comes. And one thing you should always do is have a designated point of contact, whether it's someone from legal or compliance or the front desk, to interact with the agents. You want to ask to see a copy of the search warrant, which they're going to give you. They don't give you the affidavit in support of the search warrant at that point, which has all the juicy tidbits of stuff you really want to know. You obviously want to ask for the case agent or case agent's names and business cards, because that's something your lawyer is going to need to be able to reach out to them and or the prosecutor that's assigned to the matter. And keep in mind, if there's a search warrant that the agents have, there's a prosecutor at least preliminarily assigned to that matter. And if you're really sophisticated, you should ask for that person's name, because you want to get that information to your counsel so he or she can start reaching out to the government and start that conversation, that open that line of communication, even while the agents are still there on site.
And, one of the things I've found particularly important, if you can't, for instance, get a hold of your counsel, is to look at the search warrant pretty carefully, because it's going to define the scope of what can be searched, either from the premises standpoint or what kind of actual documents can be located. And, you have a right, correct, to make sure that they're not going beyond that search warrant.
That's right. And to the extent possible, if you can have someone from the company kind of shadow the agents and kind of watch them do their work without interfering with it, and maybe make a parallel notation of where they're looking and what they're taking, would be great. Because typically in a larger federal investigation, the lapse of time between the execution of a search warrant and the filing of potential charges is often a year or two. So in that interim, many times defense counsel, we are in the dark as to what they were looking for, what they took. So to the extent you can kind of replicate for your lawyer what the agents did while they were there, it can be very helpful. But trying to identify the agents is also very good, because an experienced defense lawyer can gain a lot of insight from an investigation by who the agents are, where they're from. Are they from out of state? It can tell you a lot of kind of in between the lines information.
What do you think about, and this is, certainly a kind of a current consideration. What do you think about employees, taking out their phones and starting to video agents running around executing a search warrant?
It might be useful if they're allowed to do it. And I say if they're allowed to do it. In 90% of the search warrants I've been involved with, they're going to segregate the employees, take their devices to, one, prevent the potential destruction of evidence, and two, try to prevent them from doing just that, Phil. So typically they sit them in a room or in a lobby, take their phones, and then they go about executing the search warrant. But that would be a great thing to have, but probably unlikely to occur.
So the notion of taking employee phones within the scope of a search warrant is a really interesting idea, because you just said that a search warrant is supposed to, with some specificity, describe, what can be taken, what can be looked at. Where do employees' personal phones fit in to that analysis? And since nearly all of our phones, I think, are password protected, what can agents do and what can employees do if they're asked to, open up their phones and make them available?
By taking their phones, that reference was meant to just kind of segregate them and from an agent's perspective, secure the integrity of the search. I didn't mean to suggest that the employees' phones were subject to seizure and imaging unless they're specifically listed in the search warrant. And as far as, what an agent can do, I think that's still a developing area of the law. I know there's been a lot of, back and forth between the FBI and Apple, for example, about encryption and can you get into the device, and should you have your Face ID versus a alphanumeric passcode versus fingerprint ID, and whether it's testimonial or to force someone to open their phone. I understand those issues broadly. I haven't really spent a whole lot of time trying to figure them out, so that's probably beyond the scope of my expertise. But all those things can come into play about whether the government can get into your phone.
So, Jeff, do you have a great search warrant story from your times as a prosecutor?
Oh, well, I think I probably have different. I think my favorite story, kind of along the continuum of how to get information from a company, agents came to me from the Department of Commerce, and it was a sanctions investigation of a major company that's headquartered about 2 blocks from me here in Houston. And they were bouncing on the idea of doing a search warrant. And I'm like, yeah, well, guys, this company sits in 1,000 Louisiana. There's probably about 600 lawyers at office in that building, law firms. If we start sealing off a building, we're going to start causing all types of commotion. So why don't we take the least obtrusive view to see if we can open a line of communication? So I sent an email to the general counsel. I got up, I ran to the printer to get something unrelated. And when I got back, my phone was ringing, and it was him. And it was the quickest response I ever got from opposing counsel to a government inquiry. And he was like, what do you need? How can we help? And within a day, I had Jones Day on the other side from Dallas, talking about this case. But it probably the purest search warrant story. I'm trying to think back. I mean, we did a lot of search warrants back in the day. I think one that probably stands out, and this will ring true with you, Matthew, because I think you ultimately were on the other side. I think the day we executed the search warrants, it really got a lot of attention. I had DC lawyers calling me within an hour saying we want to cooperate, which frankly they didn't. But that wasn't the lawyers affiliated with Matthew. But it certainly was a kickstart to a huge investigation that ultimately led to a very, very large settlement on behalf of the government.
I'll add my favorite story is it wasn't necessarily a search warrant, but a client got visited twice before he reached out and said the first time the agents came and they're just super nice and just wanted him to really help him because I knew that, his bosses were doing wrong stuff. So he sat down and talked to him and just thought they were his friends. And then they came back the second time. And his comment was, they weren't so nice the second time. He ended up spending several years in the federal penitentiary, by the way. And bosses didn't.
Yeah, I think there's probably a myriad of stories. And, I think, as I said earlier, the whole idea of consent, it rarely works out well, even if you don't get charged. Search warrants, if there's a search warrant, there's probably a bigger problem afoot because the government's had enough or have enough probable cause to get a judge to sign a search warrant and they're there. If they're there for a knock and talk, they probably have some information, but they don't have enough for a search warrant. I think my favorite knock and talk investigation, it was a federal investigation of narcotics trafficking. And we had taken down the wires or ended the wiretaps and we had arrested everyone. And it was kind of proceeding through the court process. And one of the officers on the task force said, hey, we identified a house in East Houston. Now that everyone else is in custody, would you mind if we just go knock on the door and see if they'll let us search? And I said, well, given the fact that all their co-conspirators are now sitting in federal custody, you're probably not going to have any success, but absolutely, I don't have a problem with you doing that. So they go out, they knock, they get consent. And about an hour later, the officer calls me back and said, hey, we just pulled $1.1 million out of their attic in cash. So
unbelievable.
And that's just what they told you about.
So, Jeff, let's say that a company is somewhat aware that there's an investigation going on and thinks that there could be a situation where there's a search warrant that's forthcoming. Is there anything that they can and should do to prepare for it?
Well, if there's a sense that there's an active investigation of your company and you don't lawyer up, so to speak, I mean, shame on you. At that point, if a client came to me and said, hey, I think we're under investigation, I'd want to know, well, why do you think that? And there can be several tells about whether a company or its executives are under investigation. For example, if every time you fly internationally, when you come back, you get sent to secondary and customs, you might be under investigation. And I've had that happen to a couple of folks that I've represented. But I think you can get in front of a lot of it if you try to conduct some type of internal investigation and figure out what the problem is or where it is. And if you can do that, it doesn't harm you to reach out to the government and say, hey, we get the sense that we may have an issue here. Let's talk about it. I mean, most prosecutors are wanting to focus and get to the real issue at hand. So to the extent you can have an open line of communication and a real discussion, if there is an issue, that might circumvent an actual search warrant. It might not cut off an investigation or an enforcement action, but it can certainly make it, if not just more efficient, maybe less public, which has some benefit.
Right. I mean, I think this kind of goes to, and we don't want to get too far into the weeds on this, but kind of having that right compliance system and having that right corporate culture of compliance is, making sure that you're promoting employees to report potential misconduct, taking that seriously so they don't feel the need to go run to the government, because in many circumstances, companies, right, can get out ahead of this and start cooperating with the government and avoid the issues that come along with a search warrant, the least of which, by the way, is a pretty significant public relations nightmare, right? Absolutely.
And sometimes if you act appropriately as a company, you can not only avoid the search warrant, you might be able to avoid the overall investigation. And kind of going back to the case I referenced earlier, there was a lot of opportunities internally at that company to both fix and avoid government scrutiny, and they just didn't do it. And ultimately, the search warrant on the trade sanctions side was driven by a whistleblower who, frankly, when we interviewed him, said, if my company had done what I asked them to do and rectified this problem, I would have never called the government.
So, Jeff, one of the things that we've talked about before on this podcast is, what to look for going forward with a new administration. So, as priorities change and resources are reallocated, what jumps out to you about sort of the law enforcement approach for information gathering that we may see play out a little bit differently going forward now from what we've seen maybe over the last few years?
I think we're going to see a more active enforcement environment on the white collar front for a couple of reasons, or maybe more. I think one, Democratic administrations tend to be a little bit more enforcement aggressive vis-a-vis corporations and corporate entities, financial institutions. I think we'll see that in whether it's in anti-corruption, FCPA space, or anti-money laundering regulations that are new and are probably being rolled out and more aggressively enforced, and even more focused things like fraud as it relates to the Paycheck Protection Program or PPP fraud. I expect to see a lot more of that. Also, I mean, typically, for the most part, regardless of the political party of the administration, you tended to have the executive branch, at least the president's side, staying out of law enforcement activities. And I think we're going to see that going forward. So the FBI and other federal agencies are going to get back to doing what they do, and that's investigating and prosecuting folks, maybe without worrying about some of the distractions they had to deal with in the last few years.
All right. Well, thank you, Jeff. It's been great having you on the podcast. We look forward to hearing more from you going forward, and we look forward to all of your clients and potential clients knowing to say that they have a lawyer or are getting a lawyer, and that the friendly agents showing up without a warrant can kindly wait until lawyers can talk to one another.
Absolutely. It's been a real pleasure and happy to do it.
Thanks, Jeff.
Thank you for joining us on Sidebar, Bracewell's podcast devoted to government enforcement investigations, corporate compliance, and white-collar criminal defense. We'll see you next time.